I'm going to share 5 things with you that I see cause problems, the deep 6 bankruptcies all the time, and ways that you can avoid them.
Consumer warrior is on your side. The consumer warrior.
Now, the number one thing is unfiled tax returns. Tax returns, by law, most of us are required to file tax returns each and every year. If you're not required to file because your income is not sufficient or the type of income you have, some people who are only on Social Security, they're not required to file tax returns. That's one thing. But if you are working, you're employed, and you're receiving regular income and you're required by law to file your tax returns, you need to get those done before you go to file bankruptcy. I can tell you specifically here in Arizona, the bankruptcy trustees have started to enforce this very strictly. You need to have
your tax returns caught up and filed before you actually file for bankruptcy.
If you don't, whether you're in a Chapter 7 or even in a Chapter 13 bankruptcy, it can cause big problems and actually result in the dismissal of your case.
Your case is dismissed.
So if you're contemplating filing bankruptcy, go get those tax returns taken care of. Sometimes tax returns can be really complicated and they are really expensive. Often I see fairly simple tax returns that people just aren't getting filed when they could go do like a TurboTax kind of thing and get them done and get that thing ready to go so you can file your bankruptcy. So first thing is get your tax returns filed. Make sure that they are current. The second thing is joint assets. And I'm going to focus specifically on bank accounts. I can tell you the typical situation I run into almost every day here in my law practice in Arizona. And that is joint accounts that are held by parents and they're now adult children. So, you know what? I have 6 children. I know how this goes. They turn 16. You're like, it's time to get them a checking account so they can have a debit card. You go there, they're not going to let a minor open up their own account on their own. And so the parent is on the account with them. But the children have this funny way of growing up. Time goes on, they become 18, they become adults, and you're still on their account. And I get it. It's convenient. You can transfer money to them. If they need money, they're calling you late at night. They run out of gas.
Dad, I can't get a job because I have to study.
You can transfer some money to get them there. But if you are going to be filing for bankruptcy, I would highly recommend you sever that relationship to let them free. Let them become adults and have their own bank accounts. The reason being, even if you're not using that account, if your money is not in that account, if you file a bankruptcy case and you are on your children's accounts, we are going to have to disclose those accounts because you are a part owner. And if your child is using that account for jobs, school, student loans, whatever they're putting in there, we're going to have to explain and be able to prove that those are not your funds. It's much cleaner if you just take yourself off as an owner of that bank account, and then it won't cause so many problems down the road. Now, I can tell you if you do use that account and it's something where your funds are in there, their funds are in there, that's something to bring up to your attorney early on because it may be ideal to wait a little bit to kind of disentangle the funds in that particular account, let your child have that account on their own, and then just have you keep your funds separate in your own account. So joint assets, and there's a lot of joint assets, car ownership, home ownership, but I want to focus specifically on the bank accounts because that's the thing that we see the most often in my practice is the joint accounts. They don't cause big problems, but they just add more work and more inquiry by the bankruptcy trustee into your case that you can avoid altogether if you just remove yourself from the account. All right, the third thing you need to be aware of is non-exempt assets. Now, big picture idea of a Chapter 7, the law is going to legally eliminate your liability on most debts. The trade-off is they're going to look to see if you have any assets that can be sold with the money then going to your creditors. The law in every state and the federal law provide exemptions though. Most people have heard of like the homestead exemption. The homestead exemption protects equity in your home. Now it's different from state to state. For example, like here in Arizona right now in 2025, the homestead exemption is approximately $425,000 of equity is protected in your home from creditors. If you have more than that, that could be an issue. Another example in Arizona in 2025, roughly $15,000 of equity in a vehicle is exempt. Married couples can double that. They each get a $15,000 exemption. I should note the homestead is not doubled for married couples. You get the $425,000 period, even if you're married. But if you are married and you have 2 vehicles, you and your spouse each get $15,000 of equity in a vehicle. But let's say, for example, that I'll give you a couple scenarios. Let's say you have a vehicle, it's worth $20,000, it's paid for, but you only have a $15,000 exemption. That could be an issue in a Chapter 7 case. They would seize the vehicle, sell it, give you $15,000 to cover your exemption, and then take the other $5,000 to distribute to creditors. It's also a situation, let's say that you have two vehicles, you and your spouse, and you have applied the exemptions to protect those, but then you have a third vehicle that's free and clear of any liens. If you have that, your vehicles are fine, but then they can go after the third vehicle and they can seize it and sell it. They can also do that for boats, certain trailers, motorhomes, all that kind of stuff. So that's something that you're going to need to be aware of, something you need to talk to your attorney about and go through that. That's one of the main things we do before filing is really look at the exempt, non-exempt asset type situation to make sure that you can get through the process with losing and it being at least painful as possible. All right, the fourth thing that we look at are pre-bankruptcy transfers. Now, I get it. If you're thinking, hey, I need to file for bankruptcy, I don't want to lose, we just talked about losing non-exempt assets. I have this boat, I don't want to lose it. It's paid for, it's been in the family forever. And so someone will transfer it, the title, to their brother or to a cousin or something like that. Don't do that. That will cause problems. If you transfer an asset to someone, and particularly a family member, friend, what we call an insider, if you transfer that within the 2 years prior to filing for bankruptcy and you don't get anything back, you don't sell it for approximately what it's worth, then the bankruptcy court can actually go and get that back. They can take that transfer, unwind it, sell your boat, and distribute the money to your creditors. So that can cause problems. And because of that, I always say, if you're considering bankruptcy, status quo. Don't transfer things, don't sell things until you talk to an attorney who can guide you through that process to make sure that it's being done correctly. Now, if you are transferring it, if you're selling something, I've had clients who said, look, I have this motorcycle, we don't use it, whatever, we need the money, we're going to sell it, and they sell it Facebook Marketplace or wherever you're selling it, and you get fair market value, that's fine. The problem becomes when you just transfer it. With a home, you do like a quick claim deed, or you just transfer the title over to a family member, or you just give something away. That's when it can be an issue, and the courts can unwind that. So you want to make sure to disclose that and just don't do it. Don't do any kind of transfers prior to filing your bankruptcy, because it can make some big issues down the road. Those are the one kind of things that can delay the whole process, is when the trustee has to unwind those processes to make a distribution to creditors. All right, number 5. The fifth thing you want to avoid, what the bankruptcy code calls preferences. This is when you pay back a creditor and give them more than they would have received in your bankruptcy case. It's particularly difficult and challenging if the person you have paid is, again, what we call insiders, family members, close friends, business associates. And again, this is completely, human nature. I see this somewhat frequently, and never do I see bad intent. What I see is someone's like, hey,
I'm going to pay them back so that they're not involved in this whole messy process.
While I understand that can cause a problem. So if I'm filing, John's filing bankruptcy and I owe my brother $10,000, and I'm like, you know what? I don't want him to be part of this. I'm going to go pay him $5,000 right now, and then we'll call that good. The problem, if I have done that within 1 year prior to filing bankruptcy, then the court can again go to my brother and say, guess what, John's brother, give us the $5,000 back, because we're going to distribute that out to the creditors because that was a preferential payment. Now, you want to avoid that. Thanksgiving is always awkward after those preferential payment discussions, so you want to avoid that altogether. It's also important to note it can actually apply to non-family members, non-insiders, just normal creditors, but the look-back period is only 90 days prior to filing bankruptcy. So I have had clients who have said to me, hey, I have this one credit card, there's like $1,000 owed on it. I'm just going to pay them off so that, I don't have to worry about that one. One, it won't help credit. It's not going to change anything. The bankruptcy is going to cause problems, period, with the credit. So there's no reason to do that. But two, the court can actually say, hey, that's more than that credit card company would have received in your bankruptcy, so we're going to go get that money back. That one doesn't make Thanksgiving as awkward like the one with your family, but nevertheless, they can go get that, and there's really no reason to do it. So it's important to know, if it's just a run-of-the-mill creditor, it's a 90-day look-back period. You don't want to pay anybody back during that time frame. If it's a family member, friend, insider, They're going to look back a full year. And so if you've been making payments on a loan, those are types of things that need to be brought up to the bankruptcy attorney before the case is filed. The worst thing ever is when I go to a meeting of creditors and I hear about a preference or a transfer for the very first time. Make sure that you share those details with your attorney upfront, because the more you share upfront with the attorney, the more you can minimize the damage or the problems or concerns that it's going to cause, or even plan for, or maybe delay the bankruptcy filing a little bit so that it doesn't become such a big issue. Those are the 5 things you need to watch for: tax returns, joint assets, joint bank accounts, non-exempt assets, transfers, and preferential payments. There's others out there. There's a lot. It's a little bit of a landmine of Chapter 7, but I can tell you those are kind of the big ones that I see on a regular basis, that with a little bit of understanding of what to do and what not to do before you file, your Chapter 7 process should be very smooth. If you are looking to file for bankruptcy and you're in the state of Arizona, feel free to click below. You'll get a consultation with me, and it will be with me. I'm the only attorney here in my office. I will be handling your case with me and my staff to be able to help take you through this process. Even if you're not in the state of Arizona, click below. We've got a link to connect you with an attorney who does exactly what I do in your particular state. Again, thank you for watching today. Again, if you haven't subscribed, please go ahead and do it, and we will catch you next time.
Consumer warrior is on your side. The